So friends, we're about to find out whether the United States Supreme Court is going to let Donald Trump's trial in his federal prosecution for trying to overturn the results of the 2020 presidential election, whether the Supreme Court is going to let that case proceed to trial or whether they're going to stop it dead in its tracks, either temporarily or even worse, permanently. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, can we talk about Donald Trump's last-ditch effort, his latest desperate attempt to avoid being prosecuted for his democracy-busting January 6 crimes? Because now the U.S. Supreme Court has a couple of different decisions to make regarding when and if Donald Trump will be prosecuted. But before we get to those Supreme Court questions, let's do a quick recap. Donald Trump was indicted on 4 federal felony counts for trying to overturn the results of the 2020 presidential election, and he filed a motion trying to make up a doctrine that does not exist in the law: absolute presidential immunity against prosecution, or what I call absolute presidential unicorn immunity, because there's no such thing. There's no statute, no federal law on the books that supports it. There's no case law, no appellate court precedent that supports it, and there's no constitutional provision that supports the notion that a criminal president cannot be prosecuted for the crimes he commits against the American people while in office. But Donald Trump is trying to make it up. So he filed a motion with the trial court judge, Judge Tanya Chutkan, and she pretty promptly denied the motion, setting out a lengthy legal opinion, just reinforcing there's no such thing. He then appealed to a 3-judge appellate court panel, District of Columbia Circuit, Federal Circuit Court of Appeals, and those 3 judges unanimously ruled against him, setting out a lengthy and definitive legal opinion, concluding there is no such thing. Donald Trump can be prosecuted for his crimes. And now Donald Trump, of course, will be appealing that decision to the Supreme Court. But more importantly for our purposes right now, Donald Trump has until Monday, February 12th, to ask the Supreme Court to keep his trial on hold, keep it pause, keep a stay in place, rather than have the case returned to Judge Chutkan so we can get it back on the trial track and we can get this justice show on the road. So the question becomes, what will the Supreme Court do? Will they stop the prosecution dead in its tracks while they take whatever time they think they might need to address the absolute presidential unicorn immunity claim that Donald Trump is urging them to create out of whole cloth because it doesn't exist? Will they put a stop to Donald Trump's trial, or will they refuse to grant the stay and return the case to Judge Chutkan so that, as I say, we can get this justice show on the road? Now, with that recap, let's turn to the new reporting. This from U.S. News and World Report. Headline: Trump faces Monday deadline to ask the Supreme Court for a delay in his election interference trial. And that article begins: former President Donald Trump faces a Monday deadline for asking the Supreme Court to extend the delay in his trial on charges he plotted to overturn his 2020 election loss. His lawyers have indicated they will file an emergency appeal with the court just 4 days after the justices heard Trump's separate appeal to remain on the presidential ballot, despite attempts to kick him off because of his efforts following the election loss in 2020. Or, in other words, for engaging in insurrection, as a trial court in Colorado found after a full trial on the merits, and as the Supreme Court of Colorado affirmed, also found, Donald Trump engaged in insurrection, and therefore, according to the Constitution, the 14th Amendment, Section 3, Donald Trump is ineligible to hold office. But that's a different case, and we're waiting for the Supreme Court to rule on whether an insurrectionist can be given the reins of governmental power back so, he can finish the job. All of that is my editorial edition. The article continues. The filing would preserve a delay on what would be a landmark criminal trial of a former president while the nation's highest court decides what to do. The Federal Appeals Court in Washington set the deadline for filing when it rejected Trump's immunity claims last week and ruled the trial could proceed. The Supreme Court's decision on what to do and how quickly it acts could determine whether the Republican presidential primary frontrunner stands trial in the case before the November election. There is no timetable for the court to act, but special counsel Jack Smith's team has strongly pushed for the trial to take place this year. Trump, meanwhile, has repeatedly sought to delay the case. If Trump were to defeat President Joe Biden, he could potentially try to use the position as head of the executive branch to order a new attorney general to dismiss the federal cases he faces, or even seek a pardon for himself. The Supreme Court's options include rejecting the emergency appeal, which would enable U.S. District Judge Tanya Chutkan to restart the trial proceedings in Washington's federal court. The trial was initially scheduled to begin in early March. The court could also extend the delay while it hears arguments on the immunity issue. In that event, the schedule the judges might set could determine how soon a trial might begin, if indeed they agree with lower court rulings that Trump is not immune from prosecution. Okay, friends, so let's talk about the possibilities. What is it that the Supreme Court might do? Because they have a few options. Donald Trump desperately wants a stay, a temporary pause in his trial in D.C. He doesn't want that case moving 1 inch, 1 millimeter in the direction of a trial. Why? Because his hope is that he can delay it until the 2024 presidential election, and then in the horrific and unlikely event he is elected president, he can appoint a corrupt attorney general and order that attorney general to dismiss the federal prosecutions against him. And we all know he will. He may even pardon himself, go with a belt and suspenders approach to his corruption to try to stay out of prison. So he does not want his case back on a trial track. He wants the Supreme Court to stop it, to stay it, to pause it. Now, the Supreme Court could say no, because there's no reason to stop or stay or pause Donald Trump's case. It should be moving toward trial. Or the Supreme Court could say yes. Now, if they say, nope, we're not going to pause your case, that means it will be back on the trial track and it will be tried well in advance of the November 2024 election. Based on the evidence, I can tell you Donald Trump will be convicted. He will be sentenced to prison, and Judge Chutkan, I believe, will order him into the custody of the Federal Bureau of Prisons. She will not let him stay out pending appeal. That is my assessment. But if the Supreme Court says yes, we're going to do an enormous favor, though, for Donald Trump. We're going to keep that hold, keep that pause on his case so it cannot proceed to trial while we take up the issue on appeal of whether a president has absolute immunity to commit all the crimes he wants against the American people and in violation of our national laws with complete impunity, complete immunity. We're going to take that issue up on appeal. Now, the Supreme Court should absolutely not take that issue up on appeal. Why do I say that? It's actually an easy call. Because there is no law, there is no federal statute on the books saying a president can't be prosecuted for the crimes he commits while in office. There is no appellate court opinion, no case law from any appellate court in the land up to and including the Supreme Court saying that a president can't be prosecuted for the crimes he commits while in office. And there's nothing in the Constitution, not one word, even something where you could infer that a president is immune against prosecution. Nothing. So the Supreme Court should absolutely not take the case for review, which means they should absolutely not grant a stay. Let's get this case back on the trial track. Now, here is something of an outlier that I want to touch on before wrapping up. Sometimes the Supreme Court justices like to be the big dogs on the block, right? They shouldn't accept review of this case just to say, we agree with the three-judge panel that unanimously rejected Donald Trump's claim of absolute presidential immunity. The Supreme Court shouldn't just accept the case for review to say, yeah, we agree, but we're the big dogs, so we want to be the ones to author the opinion for posterity. You know, we want to set out our own rationale so people can read our very important words through the ages. But if the Supreme Court wants to be the big dogs, they want to be the ones to ultimately decide and shoot down absolute presidential immunity, fine. If you feel like you have to accept review of the case, accept review of the case, but don't issue the stay. In other words, give the case back to Judge Chutkan, put it back on the trial track, and let's get this justice show on the road. That would be the right approach if they felt compelled to write something. But taking a step back, they should reject the stay. They should reject even taking the case for review so that it's done, the case is back on the trial track, and it gets resolved by a jury of Donald Trump's peers, 12 people sitting in that wooden box in federal district court in Washington, D.C., as the conscience of the community, holding Donald Trump accountable for his crimes. So they should reject appeal, and they should reject issuing a stay, putting a stop or a pause on Donald Trump's trial. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.